Is drunk driving and DUI the same in California? Yes, drunk driving is another way of saying driving under the influence. And as it relates to the legal component in the state of California, approaching the case is very similar. But the question is that any defense lawyer is, approaching your particular case is what constitutes as being under the influence? That's going to be the hard one. But it's not our burden to prove it. It's the district attorney's job to prove it. Was it driving bad? If your driving was not bad, everything was perfectly done, and the officer just so happened to find out that you had alcohol in your system, were you actually driving under the influence or not? Because the indication of driving under influence is swerving, weaving, reckless driving. Now, there may be some objective manifestation of being under the influence, but what if that was not even shown? What if your eyes were bloodshot because you were tired? What if your eyes were bloodshot because you were out late? What if your eyes were bloodshot because, you have some sort of medical condition? What if your speech is slurred? Well, because you just naturally have a slurred speech. What if you just came from surgery? What if you're just tired? The officer doesn't know your tendency and how you speak. So how would he know generally what constitutes as a slurred speech or not? He has to have a foundation. He has to have a basis, an understanding on how you typically speak before he makes a determination if you have a slurred speech or not. These are things to look at. These are things to investigate. These are things to determine if you were actually under the influence. And these are things that we argue. At Shaw Through Law Firm, we're here to help.